Hi, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the loan contingency exhibits in the GAR contracts packages. Now, in the conventional loan exhibit, the FHA loan exhibit, and the VA loan exhibit, there is a paragraph that states right of seller to request evidence buyer's ability to close. So what the paragraph states is, I'm going to read it to you. If the financing contingency ends without the buyers terminating this agreement, the seller shall have the right, but not the obligation, to request the buyer provide the seller with written evidence of the buyer's financial ability to purchase the property. A copy of the loan commitment from each institutional mortgage lender from whom the buyer is seeking a mortgage financing to purchase the property, stating the type, amount and terms of the loan, and the conditions for funding the loan shall be deemed sufficient evidence. The provision of such evidence is not a guarantee that the mortgage loan will be funded or that the buyer will close on the purchase of the property. The buyer shall have 7 days from the date the seller delivers the notice to the buyer requesting such evidence to produce the same. No request for such evidence shall be made by the seller less than 7 days from the date of closing. So here's the issue. I really wish GAR had not put in that paragraph in the financing contingency exhibits, because basically you go through the financing contingency time frame, and what it's saying is if the buyer doesn't terminate, then the seller can request a commitment letter from the lender stating that where they are in the loan process. That's the intent, is that to give the seller some sort of feel-good feeling that the loan is going to go through, even though the loan commitment letter can be conditional and is not necessarily a guarantee to close. The seller can request it. After the seller requests it, this paragraph states that the buyer has 7 days to provide it. The seller may not request it within 7 days from closing. The problem is it puts you as an agent in a bad position with the seller because there are no seller termination rights with that paragraph. So yes, the seller may request it, but if the buyer does not provide it, the seller doesn't have the right to terminate. And the reason I say that is for a couple of reasons. Number one is earlier on in all of the loan contingency exhibits, it states that a buyer may apply for a different loan than that as outlined on the document. So a buyer doesn't even have to go through with whatever loan is on here to purchase the house. Additionally, a buyer can change loans, or a buyer could pay cash for the house. So there could be sometimes that a buyer might be changing their type of financing, and that wouldn't even apply. The other issue why I say there are no termination rights for the seller is if there were termination rights for the seller, then those would be specified within that paragraph. There would be one more sentence saying something to the effect of, should buyer not provide evidence of ability to close, then seller has X number of days to terminate this agreement. After that time frame, those termination rights are null and void. And the reason I say that is because those seller termination rights are clearly outlined within other parts of the contract. Just to prove it to you, for example, regarding the earnest money. If a buyer is supposed to remit earnest money to the holder and the holder never gets it, or the earnest money is not honored by the bank, then the holder gives notice. The buyer has the right to cure. And then it clearly states from the notice, if buyer does not do so, seller may within 7 days thereafter terminate this agreement upon notice to the buyer. If seller fails to terminate this agreement timely, seller's right to terminate based on this default of the earnest money shall be waived. So again, that's just an example where if the seller did have the right to terminate based on this issue, it would be specifically spelled out by the GAR contract, just like it is for other issues, as I just gave you the example regarding earnest money. And in all of the loan contingency exhibits, it just has the right of the seller to request evidence of buyer's ability to close, but if that buyer does not provide that evidence, there's no recourse for the seller. And again, it puts you as the agent, unfortunately, in the bad position because your seller is going to want to have some recourse if they don't get that. So just something to be aware of. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.